Hello everyone. I'm sorry my video was missing for a second, so sorry for this slight delay. Thank you everyone who managed to join us today, and if someone could not but is still interested in watching this event, we will have a recording and you will be able to watch the video recording afterwards. My name is Tatiana Neveva. I'm a co-counsel co-head of international arbitration with Yegorov, Puginsky, Afanasyev and partners. And I also have Eric Eng with me, who is the managing counsel at Hong Kong International Arbitration Court. And today we're going to talk about latest trends in international arbitration in Russia. I hope that you all read the announcement carefully, and you know that we unfortunately do not have any translation today, so the presentation is going to be in English. I think that many of you have already tried to join us through this particular platform, but in case you have not, you see that it's not very complicated. You see questions and answers signature there below on the right-hand side of your screen. So you can basically ask us questions and expect the answers in the course of the presentation, if possible. If not, anyway, at the end of the session, we'll have Q&A session, so you will be able to ask the questions then. After the presentation, you will also receive a questionnaire from our PR department. To get the presentations, you will have to fill in this questionnaire. And also you will be able to ask a question directly to me or Eric, and we will be able to contact you after the event. So let us probably start, because I already took a lot of your time with this organizational stuff. So why we are here together with the Hong Kong International Arbitration Court? Of course, this is because this is one of the arbitration institutions, foreign arbitration institutions, which got an accreditation in Russia, which is, I think, very welcomed by the Russian government and by the entire arbitration community. So we will talk about recent trends in international arbitration, on how the development of the legislation and case law actually influenced what we have now in Russia in terms of international arbitration. And then I will pass the floor to Eric, and he will share Hong Kong International Arbitration Court position on all these legislative initiatives, and will tell us how they came to this very important decision to get accredited in Russia, and how this should help them, hopefully, with the administration of Russian cases. So, key factors which we all are aware about, and which had the most significant influence on international arbitration in Russia are, of course, the arbitration reform, which basically eliminated most of the arbitration institutions and introduced the accreditation requirement. Indeed, these are sanctions, because they also influenced international arbitration and also litigation abroad with the participation of Russian parties. And the law of Lugovoy, these are the amendments to the arbitral procedural code, which were introduced last year and which were all following. Now we're looking at the case law, which is developing based on these legislative amendments. So, about the accreditation of arbitration institutions. If we look at this legislative requirement in brief, so we see that only those institutions which have the status of permanent arbitral institution now can arbitrate in Russia. And even ad hoc disputes can get assistance from, again, institutions which have this wonderful status. For foreign institutions, again, this requirement is obligatory if they want to have their award as their proper institutional awards. Otherwise, these awards are considered as issued as on an ad hoc basis. For those of you who are not aware of that, what ad hoc means, this is just a specific tribunal which is formed based on a separate agreement by the parties. So it may be not administered by any institution, but here you see that if it needs some administration and assistance, it addresses to a permanent arbitral institution. So some of the corporate disputes may only be considered by the permanent arbitration institutions in Russia, and domestic disputes as well may be considered by the same institutions which have this specific status. what if an arbitration institution has no accreditation? So I talked about the advantages, and now I just wanted to discuss one very interesting case which showed how this new legislation may be vaguely interpreted and how it can put at risk an award of a very reputable arbitration institution. This was the case which you see on the slide, Caspian Energy versus Siemens. A dispute arose between Caspian Energy Projects and Siemens. It was initially resolved by the Stockholm Chamber of Commerce, and the award was issued on in February 2020. The seat was in Russia, arbitrators were Russian, and the parties were also basically Russian. Siemens then applied to the arbitration court of Astrakhan region, arbitrage court, as we may also say, because it's not an arbitration, it's a state court for the enforcement of the award. The first instance court rejected this application in July 2020 based on the following grounds. The court said that, first of all, Stockholm Chamber of Commerce International Arbitration Court has no status of permanent arbitral institution in Russia. Then, based on Part 3 of Article 44 of the law on arbitration, this is how the court basically read these new provisions. This award had to be treated as an ad hoc award. At the same time, if we look at Part 20 of the same article of the law on arbitration, ad hoc arbitration may only be considered by the institution accredited in Russia. So the conclusion was quite logical. The conclusion was that SCC could not administer this dispute because it had no status of permanent arbitral institution. There is also one very important position of the Supreme Court of the Russian Federation, which was used by Caspian Energy in this case, but which unfortunately was not reflected in any judgments or other decrees in these proceedings. Basically, the court, the arbitrage court of the first instance, was also very cautious of enforcing SCC awards because just a couple of days prior to this final hearing, there was a review issued by the Supreme Court, in which the Supreme Court said that for this permanent arbitration institution, which has no accreditation in Russia, to consider the case, the parties have to enter into a special ad hoc arbitration agreement. So the mere arbitration clause is not sufficient. There must be a separate agreement. So as I said, unfortunately, though this position was referred to by the councils of Caspian Energy, it was not reflected in the judgment. So the judgment seems to looks a bit probably unfounded and unsubstantiated in this respect, but in fact this was actually one of the decisive points in the hearings. So the second instance court rescinded this decision and said that there was the issue of succession on the part of Siemens, which was not properly addressed by the court in the ruling, and arbitration case files were not studied. So these were like formal grounds just to rescind and to reconsider the case, because basically I think that the Court of Cassation found itself in a difficult position with this weird interpretation of the Supreme Court. So when the case returned to the first instance, the judge already read the law in a different way. Again, the same logic. SCC has no status of the permanent arbitral institution. Based on the same Part 3 of Article 44, its award shall be treated as an ad hoc award, but no separate arbitration agreement for an ad hoc arbitration is required to apply this particular regulation. So conclusion was quite the opposite. The court granted the enforcement. This decision was then upheld on the second review by the Court of Cassation, and the Supreme Court also in June 2021, you see this quite a recent decision, they also basically upheld the position and cited the idea of the court of the first instance that no separate arbitration agreement is required for the application of Part 3 of Article 44 of the law on arbitration. So now we may see that after this Supreme Court position, Basically, the awards of arbitration institutions, foreign arbitration institutions, of course, having no permanent arbitral institution status in Russia, are quite safe. They are enforced as ad hoc awards. So, but we see that most, like already four very well-known, very famous arbitral institutions from abroad got accreditation in Russia, and we believe that Eric will share with us why they saw the advantages in this and how they want to use this accreditation. You see that in 2019, Hong Kong was the first which got this accreditation, then it was Vienna Court, and this year we'll also have Singapore and ICC, International Arbitration Courts, joined this tendency. Unfortunately, none of them still have offices in Russia. So that was about the accreditation factor. What about sanctions influence? How this affected the arbitration, and why accreditation in Russia may now also help with this issue to be resolved? So after the sanctions were introduced, what we faced was lengthy compliance procedures. This was like probably the lightest consequence of all. So it just took maybe like 3 to 4 months for arbitration institutions to review requests for arbitration, to register claims, etc. But afterwards, the claims were still processed by arbitration institutions. Then the situation became worse, and the banks started refusing accepting arbitration fees. And first of all, even registration fees. So once the bank refuses to accept a registration fee, a Russian sanctioned entity cannot be a claimant. If an entity is in a position of a respondent, that's just great, because we have these cases, and this issue is very easily resolved. We just ask the claimant to pay. If the claimant doesn't pay, the arbitration does not continue. But if we're on the side of the claimant, so we cannot basically initiate the proceedings. Sometimes arbitrators would refuse to accept nomination, but this is not a very oftenly faced problem. And sometimes also I heard from my colleagues, but I have never met this myself, sometimes arbitrators would apply to OFAC for license to arbitrate a case with a sanctioned entity. But why we face this problem is, first of all, because ICC has, for instance, special banks which are not ready to pass registration fee for Russian sanctioned entities. So the accounts are open with the banks with over-compliance, let's say, because I still believe that like payment of registration fee is not such a big deal, and often it is not a sanctioned transaction. But the banks of ICC say that they do not want to face any issues with the US sanctions, and they just block the payment. This is why one of the recent trends, is choosing non-EU forums for arbitrating these kind of disputes with Russian sanctioned entities. And I hope also that Eric will tell us if this is somehow resolved by Hong Kong International Arbitration Court. How Russia reacted to this problem, we all know that there was an Instar Logistics case, first of all, which started at the beginning of 2020, which was first resolved by the Court of First Instance even before any amendments to the arbitral procedural court. The claimant was a sanctioned entity, and the opponent was a US company. The US company just refused to communicate with its counterparty because it got sanctioned. And the claimant decided not to go to ICC, which was the proper forum under the agreement with its opponent, but just brought in a claim with the Russian arbitrage court. As I said, there were no even any attempts on the part of the claimant to file a request for arbitration with the ICC court. But still, the Russian court said that it was properly fine, and that in fact there is a clear disbalance in the rights of the Russian sanctioned entity and the US company. So this entity has no choice other than go to the Russian arbitrage court, which can protect its rights. So then, as we all know, we had amendments in June 2020 introduced to the arbitration procedural court. These amendments concern the exclusive competence of Russian courts to consider disputes with sanctioned entities. And apart from that, even if you have an arbitration clause in the agreement which is valid, there is a possibility for a Russian sanctioned entity to ignore this arbitration clause based on the fact that restrictive measures prevent it from filing an from participating in arbitration or in a foreign litigation as well. The same law also introduced anti-suit injunction. So a Russian sanctioned entity can ask court to prohibit its foreign opponent to start any litigation or arbitration abroad. And should this opponent breach this anti-suit injunction, then it will be penalized severely. So the law of Lugovoy, as it is called, provides for that the jurisdiction of Russian arbitrage court starts functioning as long as the arbitration clause cannot be performed. So the key issue, which is now being considered by the courts of all instances in all the known cases based on this law of Lugovoy, is whether a party shall prove that it is somehow restricted from using this arbitration clause, or whether this restriction is implied. And here on this slide, you will see the short description of Ural-Transmash case versus PESA, which is probably the most important at this point of time, because I think that this can basically deal finally with this important question. The factual background is very different from Instar Logistics. Here, Ural-Transmash was actually participating in a foreign arbitration with a Polish company. And everything was perfectly fine. It was perfectly able to hire foreign lawyers who represented Ural-Transmash in these proceedings. So no basically problems arose for 2 years. But after the amendments to the arbitral procedural court were introduced, Ural-Transmash decided to apply to arbitrage court of Sverdlovsk region for an injunction, an anti-suit injunction. Russian court basically said that the applicant Ural-Transmash in this case could not prove that it was somehow prevented from taking part in the proceedings. So for 2 years, it would participate in these proceedings, nothing basically bothered it. Then this decision was upheld by the Court of Appeal and Court of Cassation. The Supreme Court of the Russian Federation in May again refused to reconsider the case, but we see that the fight is not over yet. And at the end of September 2021, the first Deputy Chief Justice disagreed with the opinion of the Supreme Court, of the judge of the Supreme Court, and decided to pass the case for consideration of the judicial chamber. From the online database, you can see that the next hearing is scheduled for 2nd December 2021. So it is expected that next week we will see the result, how all this ends up. But from the wording of the Supreme Court's resolution, we can also already conclude that probably the result will not be optimistic for international arbitration community, because the judge basically said that the mere fact of introduction of a company to the sanctioned list is sufficient to imply that there are restrictions. And any substantiation, any evidence of that the party is prevented or precluded from taking part in foreign proceedings is not necessary. So basically, the court, at this point of time at least, expressed an opinion that there is no need to provide any evidence of impossibility. And Here are two other cases where you can see also how courts differently look at this basically problem. The case of Power Machines versus Vostokenergo is probably the most classical one in terms of the problems which we face. So this is exactly where the claimant was a sanctioned entity and could not initiate the proceedings. So they filed with the Stockholm Chamber of Commerce, but they could not get the payment of the registration fee through. I know that some lawyers think that this problem can be overcome. For instance, you can ask your lawyer to pay, but on my side, I can say that this does not work. Because when you try to send a payment of an arbitration registration fee to the International Arbitration Institution, the banks would request the information on the case file from an arbitration institution. And once they get the request for arbitration, they will see the name of the parties. And then they can block the payment of the registration fee. This is what we regularly faced in our practice. So in this case, Power Machines versus Vostokenergo, this is exactly what happened. So they just could not pay the registration fee. The application was returned by SCC. And the claimant applied to a Russian court. The Russian court, of course, confirmed its jurisdiction. From the facts of the case, it was clear that Power Machines could not proceed with the arbitration. But if we look at Sofract versus Prosperity, that's also one of the most recent cases, and the decision was issued on the 8th of October 2021. Here the position was a bit different. Sofract applied for an anti-suit injunction, saying that it is a sanctioned entity, so it will not be able to take part in any foreign proceedings. Prosperity has not filed the claim yet, but they already alerted Sofract of that they would do so. And the court said that this was basically sufficient evidence of that there is a risk that the proceedings would be initiated. And Sofract does not need to prove that it has no opportunity to take part in these proceedings due to any sanctions restrictions, although Prosperity tried to use this argument. So we see that it's actually Sofract position was upheld by the court.
Thank you. As Tatiana has kindly introduced, my name is Eric Ng, and I am the Managing Counsel of the Hong Kong International Arbitration Center. And I'm very happy and very pleased to be presenting to you today in respect of both HKIC in general and in particular how HKIC came about to getting the PAI status, which Tatiana has mentioned, which is quite rare and that only 4 institutions at the moment have that sort of status. Just as a quick overview, HKIC was founded in 1985 and has managed over 11,000 cases to date. In the 2021 Queen Mary International Arbitration Survey, HKIC was listed by surveyed users as being one of the top 3 arbitral institutions globally. This is in conjunction with Hong Kong being a top 3 seat of arbitration around the world. So we have extensive experience in international arbitration and particularly international commercial arbitration. Let me also take this opportunity to welcome Tatiana back to the conference. I think what we said is that I'll be spending a little bit of time to talk about HKIC before we return to the Russian case law developments, and then we can sort of take it from there, if that's all right. 2020 was a record year for almost all arbitral institutions in the world, and this was true as well for HKIAC. In 2020, HKIAC registered 318 new cases. Of those, 203 of those cases were fully administered, either under the 2018 or 2013 HKIAC administered arbitration rules, or under the UNCITRAL arbitration rules. And that represents a 20% increase from 2019. Some other statistics, just for those who might be interested. As I said, the main focus of HKIC is international cases in nature. 72.3% of all of HKIC's cases were in fact international. 6.6% of those cases, in fact, involved no Asian parties whatsoever. Those cases typically dealt with either entities in the British Virgin Islands, in the Cayman Islands, or in Russia or other jurisdictions around Europe. 80% of our cases are in English. The next largest proportion is Chinese, which is about 15% of our cases. And some of these cases also involve documents that are in English, Chinese, and Russian. And we do have counsel on our secretariat staff who do speak and are, in fact, native Russians who do assist us with those cases. Hong Kong, obviously, is the most commonly chosen seat of arbitration, but we've also administered cases where the seats have been in Moscow, in London, and in Shanghai. This sort of gives you a graphical representation of our party nationality. For obvious reasons, some of our top 10 users include Hong Kong and mainland China, but we also see a significant number of parties coming from the British Virgin Islands, from the Cayman Islands, from the United Kingdom, from the United Arab Emirates, and of course, Russia is there as well.
Eric, I just wanted to ask you a question because I see that one of the top jurisdictions is BVI, indeed. Yeah. And I'm sure you are aware of that. Russian business loves BVI a lot. So lots of structures are basically made with the help of BVI lawyers. And so do you somehow distinguish these proceedings, like with the involvement of purely BVI and, for instance, Russian parties? I think it's not only Russia, but just quite many jurisdictions use BVI as an intermediary.
Yeah, that's correct. And we understand that the BVI entities usually have, say, Russian interests behind them, or in many cases, Chinese interests behind them, because the companies in the PRC also very much like using BVI or Cayman entities to host their companies. From our perspective, the administration of those cases make no difference as to whether they're BVI or not. The only time it might make a difference is when we're appointing an arbitrator. Because if we're appointing an arbitrator on behalf of, say, a BVI entity, then we are obviously excluding BVI passport holders. We are excluding United Kingdom passport holders because it is a British overseas territory. And in certain cases, we may also look at the underlying interest to see whether or not we want to appoint an arbitrator that is along the lines of that interest. But other than that, in terms of administration of the cases, we make no difference as to the underlying interest to the company, and rather we focus on the nationality and the place of incorporation of the entity. Moving on. Just to give, historically, HKIAC's strengths have always been in the international trade and sale of goods arena. Even in 2020, 27% of our cases involve international trade or sale of goods matters. However, we have also had historical strength in dealing with both corporate and banking and financial cases, share purchase agreements, shareholders agreements, issuance of shares, and other sorts of corporate disputes fall well within the ambit of HKIAC's experience in terms of institutional administration. Obviously, Hong Kong is a big maritime hub, so we do also see a lot of maritime arbitrations. And we are seeing growing numbers of both intellectual property and technology disputes that are coming through HKIAC. This is a fledgling market, but ever since the IP arbitration was allowed in Hong Kong, we've been seeing a growing number of IP arbitrations and technology arbitrations coming through Hong Kong.
And how about aviation? Because I remember that I think Shanghai opened a special international arbitration of aviation courts. I see that you have maritime, which is quite a good percentage, 18% of your caseload. What about international aviation?
We do see some aviation cases. Those aviation cases, however, do tend to be clustered under either corporate or financial services. Those tend to deal primarily with financing. And so we do deal with some aviation cases. Obviously, the bulk of our experience is from maritime, but we are seeing a growing number of aviation cases coming through the center as well.
Okay, thank you.
Right. In 2021, HKIC released a report on average costs and durations of arbitration. And these are HKIC administered arbitrations. So these aren't global, these are HKIC only. But we can see from there that the average duration of an arbitration in HKIC ranges from about 16.9 months. However, we've also taken efforts to sort of can provide options for parties to condense those timeframes when necessary. One of which is what we call the expedited procedure, which is suitable for disputes which are under, say, 25 million Hong Kong dollars or its US dollar equivalent. When an expedited procedure arbitration is on foot, that average time and duration shrinks from 16.9 months down to a little over 9 months. And you can see the cost of arbitration also shrink over half, from 137,000 US dollars down to just over 50,000 US dollars. So HKIC is working hard to help provide options to the parties to help make things more time efficient and more cost efficient.
Yeah, Eric, you know that for Russian clientele, I think that the cost factor is one of the decisive factors, basically. And I understand that you suggest like different structures of fees arrangements, right?
Absolutely. And that actually leads me into this next point. One of the things that makes HKIC unique is that we actually give two different options for the parties to help determine their fees. There is the standard sort of hourly rate calculation, which you see in many other arbitral institutions. But there's also what we call a Schedule 3 or an ad valorem calculation method, which provides compensation to the arbitrators based on the sum in dispute. Now, the reason we provide two different sort of, and maybe I'll skip ahead on this so that, because I think we actually have a slide on this. Yes. The reason we provide two different options for the parties to choose from is because depending on the way that you're calculating your fees, the amount that you're going to be paying in terms of compensation may be different. For example, in this table that I'm showing here, we've separated into basically two different categories. One where the amount in dispute is relatively low, about $5 million, but the issues in play are quite complex and will require a lot of time, will require a lot of oral hearings, a lot of factual evidence, maybe a lot of expert evidence as well. And on the other hand, we have a dispute which has quite a significant amount of dispute of about 100 million US dollars, but the legal issues and the factual issues in play may actually not be that complex and may be quite straightforward. Now, if I have a $100 million case, but it's quite simple, if I go by ad valorem, I'm paying about 264,000 US dollars in fees. But an arbitrator who's well experienced and can handle the issues quite well could be charging quite an hourly rate or charge a number of hours, which is in fact quite reasonable. And will only spend about 300 hours of work. And that brings my cost fees down to 150,000. So what this means is that there are certain aspects that I have to take into account when determining whether or not to have an arbitrator hourly fee method or an ad valorem method. Conversely, in the 5 million US dollar case, which is also quite complex, a lot of hours may be spent on that case. But on an ad valorem system, the compensation that will be due to the arbitrator is quite reasonable. And so this is why HKIC provides the two different options of cost methods to the parties. Because depending on the complexity of your dispute and the amount that you have in dispute, the amount that you're going to be paying to the arbitrators will be different. And the cost value analysis has to be done by the parties depending on that. Now, I want to take a little bit of time just to talk about Hong Kong. Hong Kong has historically been a very strong hub for arbitration. We have a very pro-arbitration legal framework. And some of the structural elements that we've put in place, some of which I'll be talking about a little bit later today, are being continuously implemented in Hong Kong to make sure that the arbitration framework remains strong and up to date. The arbitration ordinance that was for Hong Kong is based off the UNCITRAL model law with the 2006 amendments, which offer a wide range of interim relief and complete protection of confidentiality. In fact, we've amended that ordinance to provide for express duties of confidentiality, and also provides HKIC a statutory role as an appointing authority. There are other developments which have been added into the arbitration framework which aren't in the model law, including provisions that specifically allow for enforcement of emergency arbitration decisions, the arbitrability of intellectual property disputes, and the ability for third-party funding in international arbitration, something which is in many common law jurisdictions for litigation is still illegal. One of the key structural elements, though, that I want to talk about is something which was implemented in 2019. I'll skip the judiciary point for now. But one of the points I want to talk about right now is the Hong Kong PRC arrangement on interim measures. Now, for any party who is doing business with a counterparty in mainland China, you need to seriously consider using Hong Kong as a seat of arbitration because of this specific arrangement on interim measures. Under this arrangement, PRC courts can order interim measures in aid of arbitrations which are seated outside of mainland China, but only if it is in a Hong Kong seated arbitration administered by a Hong Kong institution like HKIAC. Once you fulfill those requirements, a party can obtain preservation of assets order, preservation of evidence order, or a preservation of conduct order from mainland courts. This is a reciprocal arrangement, of course, but the key development has been that it allows access to the mainland courts for Hong Kong seated arbitrations. This is something which you do not get in any other seat outside of mainland China. We have seen
Eric, and just if you allow me, I wanted to mention for those of our attendees who have no experience with international arbitration that where you choose Hong Kong as a seat of arbitration, this does not necessarily mean that you have to fly to Hong Kong for the hearing. So basically now everything is online, first of all, and secondly, you can choose the seat of arbitration to be Hong Kong and some nice venue as Paris, just to go, for a business trip once the borders are open. So basically this just allows the procedural law of Hong Kong to apply to your arbitration, but this does not mean that you have to fly so far away to have the hearings.
And that's absolutely correct. The seat of arbitration is the legal seat, but our rules specifically also state that you can have the hearings wherever you want. And that's usually based off the preference of the parties, preference of the arbitrators. And especially since 2020, the majority of the hearings that HKIC has been doing have in fact been virtual, sometimes with witnesses or with parties testifying or giving evidence from their homes, participating from their homes rather than even going to a law firm or an arbitral center. Obviously, we would recommend you go to an arbitral center, but we do have situations where that has happened. The interim measures arrangement came into force in October 2019. Since then, we've seen 56 applications in the past 2 years. Applications which are worth about 14.8 billion RMB, or the equivalent 2.3 billion US dollars. We are aware of orders that have been granted by mainland courts which have secured up to 12.4 billion RMB, or 1.9 billion US dollars worth of assets. And although the initial response might be that this is to be used against parties, mainland parties in arbitration, the statistics are actually showing that while 77% of the applicants were in fact foreign parties, 57% actually of the respondents were mainland Chinese, but 43% of the respondents were foreign. These were foreign companies which had offices or assets in mainland China. And so therefore the interim measures arrangement actually works bilaterally as well, so that it allows for either party to really have access to evidence preservation, asset preservation, or conduct preservation orders from the mainland courts. We also have a reciprocal arrangement with the PRC in terms of enforcement of awards. That's been in place since 1999 and was recently updated in 2020. And those terms are quite similar to the New York Convention in terms of reciprocal enforcement of awards. there's a very strong track record of enforcement. In over 20 years of this arrangement being in place, only 3 HKIC awards have not been enforced in mainland China. Now, this is the part where Tatiana had mentioned. It goes a little bit into our history as to why HKIC obtained permanent arbitral institution status from the Russian Ministry of Justice, as well as a little bit of the rationale and reasoning as to that application. As you've seen from the statistics, HKIC prides itself on being an international arbitral institution, and 72% of our cases in 2020 were in fact international in nature. These cases, this nature of HKIC's work means that the cases that we deal with don't have a geographical limit. And so therefore, it's not uncommon for HKIC to be dealing with cases or matters that operate across various different jurisdictions, various different geographical regions, and various different legal systems. Right? And so we are accustomed and understand that in many cases we have to deal with either certain filing obligations, licensing obligations, or other obligations. One of the examples of this is that HKIC was the first institution to establish a representative office in the Shanghai Free Trade Zone. And in fact, the Shanghai office is now one of our busier offices. With the amendments to the Russian arbitrage law, by obtaining PAI status, HKIC is able to provide and offer better parties, better choices and more choices in terms of opting for an international arbitral institution. HKIC's recognition in 2019 as a permanent arbitral institution, as Tatiana has mentioned, allows us to administer certain corporate disputes, procurement disputes, and provide some procedural implications in terms of what determination of the enforceability of an award or the enforceability of an arbitration agreement. PAI status was initially granted in April 2019. In February 2020, HKIC and the VIAC issued a joint request for clarifications to Working Group 2 and the Russian Ministry of Justice, and those clarifications were provided in May of 2020. So we can see there is a continuing and developing relationship between HKIC and the Russian Ministry of Justice to ensure that we're able to effectively administer disputes as a PAI. We've also taken significant steps to ensure that we can effectively administer Russian disputes. As I mentioned at the start of this webinar, we actually have a Russian counsel, Victoria Kondramayo, who is on our secretariat staff. We also have a Russian member on our HKIC council, which is the governing body, Professor Anton Esoskov from Lomonosov State University. I apologize if I got the pronunciations wrong. My Russian really is quite bad. But that we do have Russian members, both of our secretariat and on our council. There has been a significant impact on HKIC's caseload since we've obtained PAI status. 33% of HKIC's Russian-related cases have commenced since obtaining PAI status. We have administered approximately 30 cases, that Russian-related cases, and 10 of those have come since we've obtained PAI status in 2019. Some of these cases have no Asian nexus, apart from HKIC being the administering institution, and these involved significant Russian entities and very important Russian industries. We have a total amount of about $507 million in dispute in relation to these cases. And these cases range in size from around $50,000, which is relatively small, up to about $187 million. The average dispute size is around $17.5 million. And I'm sure, as Tatiana has mentioned, in one of the cases, parties have actually expressly excluded the jurisdiction of Russian courts, something which is only allowed when you have a permanent arbitral institution. And so we have seen the benefits of that PAI status make itself known in some of the cases which have been administered by HKIAC. Now, most of the disputes that have involved Russian parties at HKIAC are in fact contractual in nature. In terms of applicable law, primarily we're looking at English law being the applicable law, but we have also seen in these disputes parties applying Hong Kong or PRC law. I should mention HKIC has significant experience in administering disputes under English law. And in fact, as Tatiana had mentioned, 18.6% of our cases were in fact maritime in nature, and maritime by default applies English law in many of the dispute resolution clauses. These languages have primarily been in English, although some disputes have been dealt with in Chinese. Documents have been dealt with in English, Chinese, and Russian. And in the nationality of the counterparties, most of these disputes deal with Chinese counterparties, but we also have seen Hong Kong counterparties and some European counterparties. Russian claimants approximately about 40%. We have seen HKIC now being incorporated in terms of arbitration agreements. In terms of our list of arbitrators and our panel of arbitrators, we have 11 arbitrators on our HKIC panel and list who are admitted to practice law in Russia, and 27 of our arbitrators on HKIC list or panel actually speak Russian. So we are actually well positioned to provide Russian-speaking and Russian-qualified arbitrators for parties who are seeking an HKIC administered arbitration.
Eric, I just had a question about this list of arbitrators. Is this compulsory to be accredited with the Hong Kong International Arbitration Court to arbitrate the dispute there?
It is not. There is nothing in the HKIC rules which require that the parties have to appoint someone from the HKIC list or panel. You are free to choose whichever arbitrator you want. But the reason I mention this is because many parties, in terms of finding an arbitrator, will rely on the HKIC list or panel because those arbitrators have been vetted by HKIC's appointments committee as being suitable candidates, as candidates who have arbitration experience, in many cases significant arbitral experience, and therefore would be suitable to act as arbitrators. It is no way compulsory for the parties to choose from that list. But where parties may be thinking as to which arbitrator they should choose, the list and panel provide a good reference and resource. And the reason for me mentioning the Russian qualified and Russian speaking arbitrators is because for Russian parties, they most likely want an arbitrator who will be able to speak their language and will understand their law. And we do have those candidates on the list and panel who you can refer to.
Okay, thank you, Rich.
Now, just a quick bit on HKIC and the sanctions, which have been mentioned by Tatiana as well. Just as to note, HKIC, the institution, is not subject to any sanctions in the US, the European Union, or the United Kingdom. HKIC does do a screening process for any cases which are brought, any notices of arbitration which are provided to HKIC or which are lodged with HKIC. We do have a screening process where we ask the parties to identify any applicable sanctions regimes which might apply and to inform and advise HKIC how those decisions might affect HKIC's decision making or HKIC's appointment of any arbitrators. Now, HKIC also has an undertaking not to contravene any sanctions provisions vis-a-vis the banks that we typically use, which are HSBC and Bank of China, Hong Kong. Now, the banks do make the issue a little bit more complex. Tatiana has also made reference to how, in terms of ICC arbitrations, banks may refuse to accept payment or deal with these sort of situations in respect of accepting money from a sanctioned entity. All I can say on that, because there isn't, is that HKIC takes this on a case-by-case basis. In many of these cases, we find some way of being able to administer the case. So even if a party is under a sanction and we understand that there may be a situation with the bank accepting that payment, we do try to find another way or find an alternative method of making sure that we can still provide administrative services or some way that we can administer the case. Now, obviously, that's not 100% guaranteed. There may be certain situations where that may not be possible, but we do make significant endeavors to ensure that we can provide administrative services wherever possible. Our sanctions policy was issued in February 2020. You have the link there. And so you can go there and review the sanctions policy, but it goes pretty much into what I've just explained now. Thank you again for your time. I'm happy to address any questions, and I think we still have some of the slides from Tatiana that we want to get back to, so maybe we can hold the questions off to a little bit later. But thank you for your time. I hope this was informative. And now back to Tatiana's presentation.
Yes, Eric, thank you very much. It was very helpful. I had just one slide left, so if we can just have it on the screen. I could probably even echo some of the parts of your presentation now after you have provided such a detailed analysis of your cases. And I have to say it's quite impressive that your Russian-related caseload increased by 33% since your accreditation, because I remember that Hong Kong would be promoted in Russia for quite a while. This indeed was very successful, like marketing, at least marketing move, because now everyone knows that Hong Kong is the first international arbitration institution who got accreditation in Russia. And here is my presentation, and I will try to quickly go to the very final slide. Which basically concerns, again, sanctions regulations, because it looks like Lugovoy law was a very good decision, very good solution, but there are quite a lot of downsides. And prior to going to a Russian arbitrage court, the parties should consider whether it actually helps them or to the contrary. For instance, where a sanctioned entity is a claimant and the respondent has no assets in Russia, how would the decision of a Russian arbitrage court help you? It may be the case that this decision would not be enforceable in Europe, for instance, because we still have not heard anything about the enforcement of these Russian decisions based on these exception laws. And so as an alternative, you can just choose an arbitration institution, have an accreditation in Russia, and being ready to work with you as a sanctioned entity, and to get an award which can be enforced based on a New York Convention. And this may really be helpful, because where a company, your opponent, has no assets in Russia, you will most likely not be able to enforce easily this Russian court decision abroad. Again, where a sanctioned entity is a respondent having assets abroad, would an anti-suit injunction be actually enforceable in those jurisdictions? Or the courts, the local courts, foreign courts, would just disregard this injunction, and your opponent will be able to enforce against you an award, while you refuse to participate in an arbitration in the reliance on the law of Lugovoy. Then again, we need to see the position of Supreme Court on Ural-Transmash case, because so far the law of Lugovoy only changes the territorial jurisdiction, actually, of the state courts, because the non-enforceability of the arbitration clause has long been a ground for you to apply to a state court. This is just a specific situation where the law said that you can apply to the Russian court, even if you are, for instance, a claimant, so you don't have to go to a foreign jurisdiction. But if the Supreme Court on Ural-Transmash case will say that, says that you basically do not have to prove that the arbitration agreement cannot be enforced, again, I think that we may face problems abroad. And that foreign jurisdictions would not understand this very strong and very unbalanced position. Then maybe accreditation in Russia can solve the problem to a certain extent, provided that the international arbitration institutions, for instance, open accounts in Russia with Russian banks and accept payments within the territory of the Russian Federation. Then I think that for sanctioned entities, this would be relief, because they don't have to choose another seat, they don't have to apply to foreign courts for assistance in the course of arbitration, and they can just pay to a domestic bank. So nothing prevents them from initiating the arbitration. This is why, again, I would like to thank Hong Kong International Arbitration Court for getting this accreditation and assisting us in these times with the development of international arbitration in Russia. as I said, you can ask your questions now, or you can also include them into the questionnaire, which you all will receive after this presentation. So far, we have not received any additional questions, and let us just, okay. There is a question now. So in case the respondent has no assets, how do you access the potential joinder of a parent company, non-signing of the arbitration agreement? Even in case the tribunal rejoins this parent company, may we face problems in challenging the award? So the respondent, if I understand correctly, the respondent is not a sanctioned entity, and we represent the claimant who is a sanctioned entity. So we try to join a parent company. Like challenging the awards with the non-signatory parties is a separate issue. I think in international arbitration, it has quite a lot of different concepts, and this is always decided on a case-by-case basis, right? So there are piercing corporate veil provisions in different jurisdictions, which allow sometimes to join a parent company. For instance, I think you all are aware of Iggy Azaryan case, where the English court said that the parent company under Russian Civil Code has to be liable for the debts of its subsidiary, which was very peculiar reading of the Russian Civil Code, but we did see this precedent. Also, when it is seen that the signatory is basically just an empty shell company which signed the contract, but in fact the will is with its parent company. So there are quite a lot of different doctrines on this, and I think that this would just depend really on a particular case and factual circumstances. If you want to have some more details on this question, please send us an email or repeat your question with more details in the questionnaire, so that we could revert with the response. If there is no other question, then we could probably finish our presentation, and thank you everyone who joined us today. I hope it was useful. Anyway, if someone could not log in due to some conflict meetings, etc., we do have recordings, and you can actually watch the webinar afterwards whenever it is convenient for you. Eric, do you want to add something, or we can just probably...
No, I think just finish by saying thank you very much for inviting me to speak and to participate and to present at this webinar. If you have any questions, please feel free to reach out so that we can clarify what we can. Thank you again for participating. Hopefully see you soon.
Bye-bye.
Bye-bye.